On October 12, 2000, non-party Raymond Greco, an employee of City of Yonkers, sustained personal injuries when, while crossing the street, he was struck by a motor vehicle owned by non-party Keith Brunson. Brunson's vehicle was insured by the defendant State Farm Mutual Automobile Insurance Company. Greco was working at the time of the accident. Greco filed a bodily injury claim with State Farm, Brunswick's insurer, to recover damages for the personal injuries he sustained in the accident. In February 2002, Greco's claim was settled for $100,000, the policy limit for the Brunson vehicle. Greco executed a standard form release dated January 1st, 2002, in favor of Brunson, inter alia, releasing him from liability for any and all claims arising out of the accident. Meanwhile, the city paid Greco workers compensation benefits which totaled $49,962.88. Greco did not seek the city's permission to settle the personal injury action until after he had settled the matter and signed the general release. The city consented to the settlement in April 2002 in a letter, hereinafter the consent letter, in which it reserved its offset and credit rights against all retroactive, future, current, and modified workers' compensation benefits payable to Raymond Greco based upon the net settlement value received by him. The city sought mandatory arbitration pursuant to insurance law section 5105 against State Farm for equipment of the workers' compensation benefits it paid to Greco, commonly referred to as a loss transfer. State Farm asserted two affirmative defenses: that the policy limits were exhausted and that the general release executed by Greco extinguished the city's subrogation rights. It did not assert that the city's consent to the settlement constituted a waiver of its loss transfer rights. The arbitrator found in favor of the city. State Farm commenced this proceeding to vacate the arbitrator's award. The Supreme Court granted the petition and vacated the award on the ground inter alia that the arbitrator's award made no mention of the general release. We reverse. An arbitration award in a mandatory arbitration proceeding will be upheld if it is supported by the inference and is not arbitrary and capricious. See matter of Motor Vehicle Accident Indemnity Corporation versus Actino Casualty and Insurance Company, 89, New York 2nd, 214, 223, 652, New York Supplement 2nd, 584, 674, Northeastern Reports 2nd, 1349. Matter of Kemper Insurance Company versus Westport Insurance Company, 9, Appellate Division 3rd, 431, 432, 779, New York Supplement 2nd, 788. On review, an award may be found to be rational if any basis for such a conclusion is apparent to the court based upon a reading of the record. Pursuant to insurance law section 5105, an insurer who pays out first-party benefits or workers' compensation benefits in lieu thereof is afforded the mandatory intercompany arbitral process to recoup payment of those benefits through a loss transfer. See Doherty versus Barco Auto Leasing Company, 144, Appellate Division 2nd, 424, 426, 533, New York Supplement 2nd, 9762. This mandatory arbitration provides the sole remedy for loss transfer. Id. An insurer does not lose its loss transfer rights as part of a personal injury settlement absent an express waiver of those rights. Allstate Insurance Company versus Mansfield Auto Company, 159, Appellate Division 2nd, 969, 552, New York Supplement 2nd, 770. See matter of Kemper Incorporated Insurance Company versus Westport Insurance Company, Supra. Doherty versus Barco Auto Leasing Company, Supra. In the case at bar, the city did not expressly waive its right to seek recovery, but the general release executed by its insured did not affect a waiver of its loss transfer rights. Thus, the arbitrator's determination was supported by the evidence in the record. See Doherty versus Barco Leasing Company. The instant case arises out of an accident involving a vehicle insured by the petitioner and Raymond Greco, a pedestrian employed by the city of Yonkers, who was crossing the street at the time of the accident.
Okay.
It's timed out at 150, but it's way behind. About 135.